For today's story, we have a story about an attorney that won $1.5 million for their client, but no, not so much. The judge has ordered a new trial because the attorney in question posted some things on social media that the judge had some problems with. So, way to go to get rid of that $1.5 million you got for your client. Let's learn a little bit more about this. Plaintiff's counsel Mike Ruffy and Alex Brown of the Ruffy law firm had secured $1.5 million in a verdict for their client in an automotive tort case. But rather than pop the bubbly, how about a retrial? The Gwinnett County, Georgia State Judge, Rhonda Colvin, vacated the jury verdict and set a date for a new trial. How about let's give it another go? The reason for the extraordinary step is that Ruffy made a series of social media posts, including gems like 3 lies we tell jurors and updates on the case that Colvin said went beyond a matter of public concern. So, yeah, you're posting some things on the social media and, it's not great. And, don't do that. As reported by law.com and granting the new trial, Colvin was aware of competing interests that she had to weigh. In a 6-page order, Colvin wrote that she'd been hesitant to overturn the jury verdict, noting it's a violation of Rule 3.6 alone is not a proper vehicle to obtain a new trial, but concluding that as part of the court's duty to protect the integrity of the court process, broad discretion in ensuring no verdict is contrary to the principles of justice and equity. In addressing the social media post, Colvin deemed it difficult to find the balance between protecting the right of a fair trial with free speech and free expression. Good times. But ultimately, what the judge found, the potential impact of Ruffy's concerned posts were too great. The court is deeply concerned with the impact of these social media videos. The videos contain sufficient specificity to determine he was beginning a jury trial in Gwinnett County the following Monday. His video specifically also set out that the defendant had insurance, the defendant insurance carrier paid for the witnesses, and that the defendant had been arrested on the scene. So he is bringing information. The problem is that he is bringing information to the jury's attention that they shouldn't know. He is basically violating the rules of evidence, right? There are rules for how you do things. And he's talking about the case with specificity, including by bringing information to the jury's attention they are specifically not supposed to know because it's all legally irrelevant. So the judge is over here like, I can't help noticing you made these social media posts in advance of the trial. Maybe jurors saw it and, that influenced their decisions. So, you are violating the rules of evidence because you're trying to go outside of it and basically poison the jury well. It's going over super great over here. This led the judge to use discretion to grant a new trial in the entirety, during which presumably jurors could be vetted on whether or not they've seen social media posts about this, and hopefully they'll be able to resist. Okay, so now we're going to watch this video that Georgia lawyer posted on his own Instagram, which he has not taken down, one will note. And we will discuss this post that he apparently made in preparation for the jury trial, and we will discuss what he says and go from there. So let's go ahead and listen to this.
Let's talk about 3 ways that lawyers and judges lie or at least mislead jurors. This came to my mind because I'm in my office putting on the final touches to my opening statement that I'm going to use on Monday in a car crash case I have going forward in Gwinnett County, Georgia.
I am working on my opening statement for a car crash case I am going to deliver on Monday in Gwinnett County, Georgia. See, this is the problem, right? He's talking about things that are going to happen, and he is potentially influencing a future jury pool. He's like, here are some lies that we are going to have to tell to the jurors. Let me tell you about them in advance, in preparation for this thing, for the trial. I am going to start on Monday in Gwinnett County. It's a car crash case. Okay, look, what are these lies? Tell me more.
I'm excited about the case. I think it's going to go really well. I'm excited for my client. He gets his day in court. I'm excited to give you guys updates. It should be a short.
Good news, friend. He's going to get 2 days in court because he had his day in court, but have to do it again. So I hope he liked it the first time. Let's do another one.
Short trial, just a couple days, but I'll give you updates. It's not going to be as exciting as the Burnock trial, but I'll do my best. The first thing is probably the biggest one. We can't talk about auto insurance. Cannot say that the defendant has auto insurance, that the defendant's lawyers are handpicked and paid for by the auto insurance. We can't say that that really expensive expert they have in this case that bills at more than $1,000 an hour and has made however much money in this case, that he is paid for by, you guessed it, the auto insurance. So we cannot talk about auto insurance at all. And that's really frustrating because you have to pretend like this thing that everybody knows sort of exists just doesn't appear or is non-existent in this case. And sometimes that confuses jurors.
Okay, the reason that you can't talk about the audio insurance is because it's legally irrelevant, right? We're in on a car crash case. The issue is, did the guy cause the damage? And if so, how much damage did he cause? Whether he has insurance or not is completely irrelevant to any issue in the case. It's irrelevant to fault. It's irrelevant to who caused the damage, and it's irrelevant to the amount of damage, right? Whether he has insurance or not, it doesn't change. It doesn't change anything. So you're not allowed to bring it up because it's completely irrelevant to any of the issues the jury is to decide. The jury is the finder of fact. The facts that the jury has to decide is who caused the crash, to what percentage did they cause the crash? Is it a 90-10 thing, 95, is it 100-0? Who caused the crash? How much are they responsible? What is the total amount of damage? It's irrelevant. Also, we don't allow you to talk about it because we are under the belief that if we did, it might prejudice the jury because they might think, this is just a auto insurance who's going to have to pay. So we'll just soak the insurance company. Well, the problem with that, of course, is that would raise everyone's rates. If jurors constantly were like, we would soak the insurance company, it would cause everyone's insurance companies to go up, Oh, the insurance company has to pay for it. Bullshit. You and I have to pay for it. We have to pay through our insurance rates. So it would be bad as a matter of policy. So it doesn't make any sense as a matter of policy, and it's completely illegally irrelevant. The liability is completely based on who did the what and how much. Insurance is not a factor in this. Now, as to the expert, you can ask the expert how much they're being paid. What is your rate? How much are you charging? How many hours have you put into this? How much have you billed? Because it goes to potential bias. So all that's fine. You just can't simply ask who's paying for it because it doesn't matter. The amount that they're being paid, they're an expert for their side, right? You were hired by the defendant, right? Yes. Okay. You're being paid $1,000 an hour, right? How many hours have you done on this? 10 hours. Okay. So you've already built $10,000 worth of time, right? Right. All that's fine because that goes to credibility. It goes to bias, but who's footing the bill doesn't matter. You've learned everything already. So you don't bring it up because it doesn't matter. It's legally irrelevant. How do you not understand this? Let's listen to some more.
The second thing, and this is pretty particular to this case, although I've had it in other ones too, is we have to lie to the jury about what happened after the crash. So in this case, after the crash, the defendant was arrested. She was arrested for driving without a driver's license. And I can't tell the jury, one, that she was driving without a driver's license, or two, that she was arrested for that. The inquiry, basically, about who caused the crash stops at the crash.
Right. Correct. 100%. Yes, you got it. The inquiry about the crash stops at the crash. How could anything after the crash change any facts about the crash? The issue, again, in an automobile accident is who did a bad? Who is at fault? This could be one person. It could be multiple people. It could be both of them. It could be only part of it, right? So is the defendant 100% responsible, 95% responsible, 50% responsible? Who did a bad, right? But what happened afterwards irrelevant. Okay, did they cause an accident? Yes. Does the fact that they have a driver's license or not have anything to do with that? No, it doesn't. It has nothing to do with anything. Does the fact that they got arrested have anything to do with the accident? No, it doesn't. It has nothing to do with anything. Amazingly enough, the accident stops at the time of the accident. How is anything else relevant? What you want to do is you want to bring in just prejudicial information. It is not probative, sir. It is not probative because it doesn't help the jury to decide any of the issues they have to decide. Who is responsible? By how much? How much damage was caused? Was the person arrested afterwards? Who cares? Do they have a driver's license? Who cares? You want to bring in irrelevancies. It's prejudicial. You can't do it. It's irrelevant. You can't do it. How do you not understand this? What is your problem?
So I get it, and maybe you do too. Whether someone has a driver's license or not doesn't actually mean that they did or did not cause the crash. And
You got it. That's it. You got it. That's right. Whether they have a driver's license or not doesn't mean whether they did or did not cause the crash. That's correct. Right. If they have a driver's license, it doesn't imply that they didn't cause the crash, and the other way around. You got it. You got the answer. It's irrelevant.
same thing with whether they were arrested or not. But it's really frustrating to have to pretend that this defendant is, gets in the crash and theoretically goes home and has the rest of the day, sitting at the TV doing whatever. No, she got arrested, and I can't tell the jury that.
It's irrelevant. It's prejudicial. It has nothing to do with anything. You just want to bring it in because they're like they're a bad person. They're a bad person because they don't have a driver's license. They're a bad person, and you should find them liable because they're a bad person. You want to use character to go after a person's liability. We don't let character evidence in, sir. It's in the rules of evidence. You can't do this.
The third thing is that the defendant has made offers to settle the case. And this goes both ways, but frankly, I'd be happy to share with the jury all the offers we've made and how many times we've tried to settle this case. Where this gets frustrating for me is that in the defendant's closing argument, and I guarantee you this, I guarantee it, I'll do a follow-up video proving that I'm right, but I guarantee that the defense lawyer will stand up and say, the jury should award $0. Defense lawyer is going to say my client caused the crash. He didn't. And that he's not really hurt. He is. I can't stand up in my closing argument and say they know that's bullshit because they've offered this much money already to settle the case.
Okay. Just no on every possible level. Yeah, there's a pretty good probability that the guy's going to get up and be like, yes, I am 0% responsible. Then he wasn't really hurt. There's no damage. You should find an award of 0. That's a pretty reasonable bet. I mean, they might say something other than that, depending on the nature of the thing. But yes, the idea they're going to get up there and be like, we didn't do anything. We're not responsible. There is no injury. We didn't cause the injury is a pretty reasonable bet. Settlement conferences are legally protected. They're legally protected. You can't use them as a juror, you can't use them as a lawyer. Specifically because we want people to have the ability to decide whether to settle or not, right? And if they used it against them, people wouldn't have the discussion, and that would be in a frustration of the administration of the court process. Plus, people settle for reasons other than because they are liable, right? Even if I believe in my utter heart of hearts, even if I truly and absolutely believe that I didn't cause the injury, there is no injury, you're full of shit. Even if I truly, absolutely believe that, I might settle because I am mitigating my potential loss, right? Maybe the jury disagrees with me because I know there's a pretty good probability that the jury is just going to, make a bad call, and I'm mitigating my potential damages. So it is in my interest, potentially, to settle for perhaps a nuisance value. Right? What is the cost to me? So it's like, okay, I'm going to settle just for nuisance value, or I'm going to settle for a minimal value in order to mitigate risk. Not because I think I did a bad, but because it's in my interest to do so. Now, maybe I don't do that because I'm like, screw you, I'm going to stand on principle. But the fact that I offered to settle this case is not an admission of liability. It's, can we reach an agreement that mutually mitigates our respective liabilities? And right now, my liability for the jury is potentially millions because apparently the jury found 1.5 million. So I want to reach a settlement, but that doesn't mean I think I'm necessarily responsible. That means I'm realistic. So if we can reach an agreement, then great. But settlement conferences are legally protected. They're also legally protected, incidentally, in criminal cases for exactly this reason, right? It is if the defendant has a conversation with the prosecutor and they are talking about a potential plea deal, and there's negotiation over a plea deal, but no plea deal is ever reached. You'll never hear about it in trial. You'll never hear about it in trial, right? We want the defendant to have the ability to talk to the prosecution and be like, okay, I'll agree to plead to these things, these things, these things. If they could use that against you, then you never have the plea agreement. So we have it protected so that people can see if there's a way to reach a mutual resolution. It's true in criminal trials, it's true in civil trials. These conversations are legally privileged, protected for the administration of justice. And no, you can't bring up that they offered to settle because, again, also it's irrelevant to the issue. The issue is how much damage did they cause, which is determined by the facts, not what the offer was. This is irrelevant. You know better.
And that's really, really frustrating, but the jury's not allowed to hear about any offers. So those are three lies either we actively have to tell the jury or ways we have to mislead them to not mention something or at least lie by omission. And it's frustrating sometimes. There's some good reasons, but maybe you find this interesting.
I find it interesting that you're going to have to retry your case again. I find it interesting that you have to do a do-over and screwed over your client. I find it interesting that $1.5 million award went bye-bye. I find it interesting that you have not taken down your Instagram posts and are continuing to tell people, that you don't understand the basic rules and stuff. And I also find it interesting that you're prejudicing juries. So I find all that very, very interesting. And thus, that brings us to the end of this case of this attorney who's going to have to do a do-over because apparently he doesn't understand rules of evidence and doesn't seem to have any problem with polluting a jury pool. And he's going to have to do a do-over on his award because he might have prejudiced the jury that was going to hear the case. At least for the moment, that brings us to the end of discussion of this story.